SJC-09850, Commonwealth v. Gregory A. Wall.
All right, let's proceed. Good morning.
Good morning, Your Honors, and may it please the Court. My name is Matthew Kamholtz, and I represent Gregory Wall. In this case, there was a confluence of errors that, working together, denied the defendant a fair trial. The first of those concerned the admission of a series of tape recordings that were made between the defendant and his girlfriend, who at the time was incarcerated at MCI Framingham. These tapes served to not only, they were offered for the limited purpose of showing that the defendant
was not in a stupor, that
that's
he was
correct.
awake and that he was functioning, and that his defense was that he had passed out. And so these tapes showed that he wasn't passed out.
His defense was twofold. Number one, that he was passed out at the time of the offense, and that it was a third-party culprit defense, and that he was passed out at the time, and that the boyfriend of the victim was at his house, that the victim and the boyfriend were arguing, that he passed out, and he woke up and he saw the dead body there in his apartment. The alternative defense was that if the jury in fact found that he was in fact the culprit, that his state of intoxication was such that he couldn't form the necessary intent to commit first-degree murder.
So why wouldn't the tapes be relevant on both of those issues?
Well, I'm not saying that they were irrelevant,
Okay.
but this error, combined with all the other errors in the case, worked to undermine the defense of intoxication in both regards.
Remind me that the tapes were on the same day as the murder, yes?
That's right. There was a series of tapes. There were 5 recordings beginning at 10 o'clock in the morning and ending sometime after 8:45 or so. A period of over 10 hours. The first tape, by the way, is completely irrelevant. I don't see any relevance there whatsoever because he clearly hadn't started drinking by that time. And the only information in that tape of any significance in the trial, which was prejudicial, was that he was in fact on probation at the time. But the defense, the evidence of the defense came in through the defendant's statements that were made by the defendant at the time of his arrest, and statements that were made in the hospital after the police took him to the hospital from the police station after he told them that he had taken Ativan and that he had been drinking all day long. So the defense really depended on the jury finding his statements credible, believable. And so what these tapes did was to really undermine the chance of the jury putting any credence at all on any of the defendant's statements, because they served really to completely assassinate, I would suggest.
Did they show that he was functioning? Did they indicate that he was alert?
I think that the tapes certainly show that he was awake insofar as he answered the phone. And by the way, that could have simply been established by playing the first 30 seconds of each tape to show that he was awake. And it certainly showed that he was intoxicated, but the government's position was that he was not so intoxicated as to be passed out or incoherent. I think that he was somewhat incoherent in these tapes. And by the way, I urge the court to listen to them. These tapes last over an hour in aggregate. But
I'm confused. So it somewhat supports the view because it somewhat shows he's intoxicated.
it does.
So where is the part that his credibility is undermined, except other than the fact that maybe the jury could infer that he actually wasn't that intoxicated and he was awake?
Because, except for the first tape, the balance of the remainder of the tapes is a constant flow of invective from this girlfriend to the defendant after he told her that he had essentially taken her paycheck, forged her name, cashed the check, used the money to buy beer, and throughout these tapes, on end, I mean, these phone calls are about 20 minutes long each, and from beginning to end, starting with the second phone call, she is berating him, she is yelling at him, she is cursing at him, she is saying that you're a liar, you're a cheat, nothing you say can be believed, you're a bad person. It's just, the dam's just opened up. And the prejudicial effect of these tapes was really just overwhelming. The probative value of these tapes was really very, very limited. And it could have been established through the testimony of the girlfriend that she made the calls and he was awake. It could have been established by just playing small parts of the tape. But the thrust of these tapes in its entirety, and again, I urge the court to listen to them because the transcript does not do it justice. I mean, the tone of her voice, the haranguing, the constant vituperative language, it is really quite an incredible series of phone calls.
Chris, if it could have been done by the girlfriend, if the Commonwealth was limited to the girlfriend testifying about his state of sobriety, in the tapes not admitted, she would have been impeached because he had stolen her paycheck, and that her comments about his sobriety would have been questioned. But here it's really almost like direct evidence of his sobriety.
Well, it is.
Isn't it like the best evidence of his sobriety? How he sounds on the phone, his ability to respond to statements, to questions, and carry on a coherent conversation.
I'm not suggesting that it's irrelevant at all. It was relevant. But the issue is whether or not that relevance was overwhelmed by the prejudicial effect of these tapes and the way the tapes themselves were handled. I mean, the defense counsel went to the sidebar. There was a sidebar conference before the tapes were admitted. And a blanket objection was made to them, essentially saying that this was character evidence and none of it should come in. The judge wanted to know particularly if there was any problem with any particular matter in the tapes. And the prosecutor suggested, well, there is this matter of cashing of the checks, really suggesting, I think, to the court that it was some kind of a limited conversation. And the judge wanted to know whether or not that could be excised. And the prosecutor said, no, it couldn't. And, you know, it was kind of an odd conversation because if it was just a limited reference to cashing a check, there's no reason at all why the tapes couldn't have been redacted. But, in fact, the prosecutor was, I don't think he was correct, but it would have been difficult, I think, to redact these tapes because the discussion of cashing the check and stealing the money and being untrustworthy and lying over and over again pervades every conversation throughout these tapes. So it would have been difficult, and it would have really resulted in essentially playing, you know, the first few and last few minutes of each tape, which I think would have been fine and would have proved everything that the Commonwealth needed to be proved.
And you're not really pressing, though, the argument that that's bad acts, the cashing the check, because she gave a curative instruction about that.
Well, she did give an instruction. She gave a limiting instruction. Right. But, you know, when the prejudice is as pervasive and as overwhelming as it was here, I don't think that the court should rest on that to really excuse what happened here.
To what use did the prosecutor make of the tapes in closing argument?
Well, the closing argument, I think the tapes formed a background for the Commonwealth's argument. He didn't reference the tapes specifically, I don't believe. But, and this gets me to my second argument, which has to do with the admission of evidence concerning whether or not the defendant had taken Ativan that day. He told, at the time that he was arrested, he told the police that he had been drinking and that he had taken Ativan. And in fact, there were dozens, I think, I don't know the number, but there were many, many beer cans strewn throughout the apartment. And by the way, it's very interesting that defense counsel, in attempting to raise this issue of intoxication, asked every one of these police officers, well, what was his state when you encountered him? Did you smell alcohol on his breath? Was he coherent? Was he, so on? And almost to a man, the police denied any effects of intoxication, which was really quite remarkable. One officer only, and I would suggest the most credible of the officers, said that he was incoherent, that his eyes were bugged out, and he was clearly debilitated.
That was the
Only
first
one
time he was
officer.
found in the closet, right?
That's correct.
But
oth-
he wasn't this, the defendant alcoholic that would have had a high tolerance for a lot of alcohol?
Well,
Was
I
that-
don't know one way or another what his tolerance was, but this officer
Sense about that?
testified that he was incoherent at the time of the arrest.
Mm-hmm.
None of the other officers would admit to that. So defense counsel was very interested in getting into evidence as much as possible the fact that the defendant was intoxicated. And so he offered into evidence a portion of a medical record from the Quincy Medical Center. What happened was, after the defendant told the police that he had taken Ativan, not only at the time of the arrest, but in the police station as well, the police took him to the hospital, where they did a serum alcohol test based on drawing blood, and it was extremely high, the equivalent of a 0.21 blood alcohol level, far beyond the experience even of these police officers who testified to arresting people for OUI and so forth. They'd never seen anybody with that high an alcohol level. There was a discussion at the sidebar about putting this excerpt of the medical record into evidence, at which point the prosecutor said, well, I've got the whole thing here, and I was really intending to put the whole thing in, so why don't you just offer the whole thing? And defense counsel agreed to that, completely oblivious to the fact that contained within that medical record was a report of a toxicology screen showing that the defendant was negative for benzodiazepine, which is Ativan is a benzodiazepine. Right on that report was some language saying that this is a screening test only, the results haven't been confirmed, and there's case law where this court construed language that is essentially identical to that language, showing that these kind of preliminary screening tests are not admissible, that this is not reliable evidence. Counsel was completely unaware, oblivious to it, really. And it was counsel himself who offered then the entire medical record.
Not admissible as a medical record or a basis on which someone on the, I understand there was someone on the list who would have testified to an opinion regarding that result? There was evidence in this.
There was no medical expert testified.
Right.
Somebody may have been on the witness list. I'm not certain of that, but the medical record came in for its full probative value without any testimony one way or the other than the stipulation as to what the blood serum level meant, the equivalent to a 0.21. But to get back to your question, Justice Spina, as to how this was used in the final argument, well, the prosecutor referred to precisely this negative result in his final argument, together, by the way, with other, and let me just address this other matter as well, with respect to the Ativan. There was, in addition to the medical record, there was also testimony which was thoroughly impeachable, offered by the girlfriend at trial in cross-examination, telling defense counsel, well, he asked her something about taking Ativan, whether he had a prescription for Ativan, and she said, well, yeah, it makes him crazy, but he didn't take it that night because I threw it out. Well, of course, she'd been locked up for 3 or 4 days, so how she knew whether or not he had taken Ativan is something that surely the jury should have questioned, and I imagine that they did. Nonetheless, she was not specifically cross-examined on the basis of her knowledge.
How did defense counsel handle the question of Ativan, if at all, in his closing?
He simply said that the evidence was, that the jury should believe Officer McGovern, who testified that he was incoherent. There were all these beer cans. I mean, I don't think he addressed Ativan specifically, but he addressed intoxication in general. But the girlfriend had been interviewed by a psychologist who had been, who worked at the Bridgewater State Hospital, who had prepared a report of criminal responsibility evaluation, and as part of his collateral sources had interviewed the girlfriend. And the girlfriend told the doctor, and the doctor reports it in his report, that the girlfriend told him that in fact he had been drinking all day and that he had taken Ativan. Now, again, she was locked up at that time. We don't know what the source of her knowledge was, but she made that statement without any caveat, without any conditioning.
Doesn't that actually say that it was reported?
I know the Commonwealth says that in their brief.
That's
but
not what
that's
happened?
not what the report says. The report says she told me that he had taken Ativan and been drinking all day. So the report itself is in the appendix, and you can read the actual
Wasn't there also
report.
something in the transcript where she says that he was telling her he was looking for the Ativan while she's in jail, and he's saying, I'm looking for it, and so suggesting that there wasn't any to be found?
I don't recall that, Your Honor. But
Well,
so we have these two pieces of evidence that I suggest should not have come in with respect to the Ativan. And the Commonwealth then, now to finally address your question, used both of those to say the defendant is a liar. You know, in his opening, the prosecutor says, the defendant says he was taking Ativan. Well, look at the report. No drugs in his system. What did the girlfriend tell you? No drugs at home. He lied to his, and then there was something about some statement that he made to his mother about being on drugs. He lied to his mother. He lied to the police. And of course, the inference, he lied to you through the police or through his counsel. This theme of him being a liar was really in the background of this case.
Well, he told several different stories about how this woman who was cut to pieces got in his kitchen. Was it his kitchen?
That's right. He did, well, you know, I know that the Commonwealth makes much of that, and they did a trial, but the stories are not that different from one another. And I would suggest that somebody who did have a blood alcohol level of 0.21, somebody that was being interrogated repeatedly by teams of cops, you know, to be asked the same questions over and over again. You know, I don't think it's unreasonable that his stories didn't coincide in all the details all the time. I mean, these were not night and day stories. These were really small differences. So using this essentially inadmissible evidence, combined with the really pervasive prejudice caused by the admission of these tapes, the Commonwealth was able to completely undermine the defense and really prevent, I think, the jury from evaluating in any fair sense the defendant's account of what happened, which came in through his statements.
could you address that closing? I'm wondering if you would get to the closed courtroom argument.
I'm sorry,
You have a closed courtroom argument?
yes,
I'd like you to get to it if you could.
Yes.
Thank you.
Got a minute.
Okay. The public trial issue was raised in the defendant's second motion for new trial, which was, of course, filed before this hearing, obviously, before 33E review had been accomplished. The trial judge declined to even consider it, and I think that was, frankly, a serious mistake on her part, and really only is going to serve, I would suggest, to prolong these proceedings. Because, of course...
I take it after his conviction, appellate counsel was appointed,
Yes,
and the first motion for a new trial was filed by appellate counsel, not trial counsel.
that's correct. That's correct.
Second motion for a new trial several years later,
It was filed by second
by you.
second appellate counsel. That's correct.
And she said, the judge ruled that essentially by not having raised this either at trial or in the first motion for a new trial, it was waived.
Right. Well, it certainly couldn't have been raised at trial because no one is aware, the trial counsel himself was not aware that it had been, that the courtroom had been closed. So that's
We
not.
have an affidavit from trial
We
counsel.
do. But I would, with respect to what the court should do about it now, the case on point is Buckman, where in precisely the same situation, in a second motion for new trial, the public trial issue was raised, and the trial judge didn't make adequate findings. In fact, didn't even consider it. And it came up here, and following argument, this court found that in order to address the issue that there needed to be findings, and remanded the case for further findings on that issue. And I think unless the court is inclined to accept the affidavits that were filed as being true, which I would welcome, but if you were not inclined to do that, I think the only alternative is to remand this for further findings. Number one, was there in fact closure? And if so, was that justified under the circumstances?
All right, thank you, counsel.
Thank you, Your Honor.
Good morning, Your Honors. May it please the Court. Tracy Cusick for the Commonwealth. Your Honors, I'll start with the closed courtroom claim. It's not necessary for this court to remand the case for findings. It really hinges on the standard of review. For the defendant to prevail under any findings, this court would have to find that this court would apply structural error analysis to a claim that was waived by not being raised at trial, by not being raised in a first motion for new trial. So certainly, Your Honors, I suggest that this court should find that the defendant would not prevail under any findings if, even as he states the case were, that his uncle was in the hallway, which again, we have the uncle's affidavit. We don't have any findings from the judge as to that, or whether the defendant knew or should have known about this. I don't believe there's any affidavit from the defendant in there, and I believe there is something in the record that suggests that the uncle had brought clothing to the courthouse for the defendant.
I think that's what the uncle says.
Yes,
That
and
he
that
came there with clothing for him to wear during the course of the proceedings, so.
So certainly, it seems that the defendant, I'm not sure what he would say, but that would certainly suggest where'd your clothing come from. Also, that the uncle was, it states that he was a long-time connection with many of the people in the courthouse through his work, and that somebody, in fact, said, we'll call you when it's time to come in. So certainly that would be something that could be explored, but I suggest it's just not necessary, again, because the issue was not raised below or in the first motion for new trial. Your Honors, with respect to the telephone calls from the girlfriend who was incarcerated, certainly the fact of her incarceration was before the jury. It was not a secret that she was not actually in the apartment on the day of this incident, or a couple of days beforehand, to have personally disposed of any drugs that might have been in there. But also, in reviewing these, it seemed to me that actually some of them might have been even admissible substantively. The part about the, don't let your mother come over here. The girlfriend had been making statements about sending her mother over to the apartment to collect some of her belongings, and the defendant was discouraging. Now, it wasn't substantively before the jury, but possibly it could have been. That's certainly not how it played out. In this case, the defense opened the case by announcing that the defendant and the girlfriend were a couple of drunks, and really talked quite a lot in a disparaging manner about their habits and their sorts of activities. So certainly in light of that evidence, that was his theory of the case, that these people just drank a lot and used drugs. That was his theory of it. These calls fit completely in with that. So I'd suggest that these couldn't be bad character evidence in the facts of this particular case. And again, there was an instruction from the judge as to what the limited purpose of these calls, which certainly showed that the defendant was awake, was answering the phone, was responding to questions that were being asked, that he was not incoherent or incapable of participating in a conversation. And certainly the evidence of the police officers who encountered him that night and into the next day. Certainly there is different perhaps opinions or observations as to his sobriety, but again, where you have a defendant who, from the record, one could determine that he had a lengthy history with alcohol, that certainly his high blood alcohol in those circumstances isn't inconsistent with observations of police officers, that he did not seem to be intoxicated.
Well, what are we to make of the first officers that saw him, the testimony about him being bug-eyed and
That was certainly that was that officer's observation, and I suggest that when somebody is found by the police in a closet after having dismembered somebody who had just been murdered in another part of the home, that certainly might be the way somebody appears. It's a rather unusual circumstance in which to find oneself in, and perhaps that's just the way he looked. Or maybe it had something to do with the intoxication, but certainly he came out of the closet and was then taken into custody by the police, and there were further interactions with the police and interactions with medical personnel at the Quincy Medical Center.
How quickly after he was taken in was he then taken out for observation? I know he was gone for observation for 5 hours, but what was the time frame between his being picked up and then sent out for observation?
Your Honor, my recollection is the police arrived around midnight, and I believe the ambulance was at the police department. I believe it's around 1 o'clock. I think it is in the record.
Yes. I
The
remember that
timing of
part.
this, but it was a pretty short time. He was brought to the police station, was making remarks about having consumed pills. The police didn't know what Ativan was, didn't know anything about it, so they called an ambulance and had him brought to a medical facility, at which point he was evaluated by somebody there, Dr. William Baker, who was on the Commonwealth's witness list. His name was announced to the jury as a potential testifying witness in the case. He did not testify, but with respect to the medical record issue, had this issue, the concern about the preliminary nature of a test of the presence of drugs in his system been raised, certainly that evidence would have come in some other form if that objection had been made and sustained. And I suggest that this case is actually quite different from those other cases, the OUI cases. First of all, the consumption or non-consumption of drugs or alcohol were not elements of the actual offense. And in this case, the defendant reported to police having consumed drugs and alcohol, but drugs with which the police were unfamiliar. So they called an ambulance and took him to Quincy Medical Center. To not have included the fact that some testing was done to address his claim of drug consumption certainly would not be giving the jury a full picture of what occurred. It would be potentially misleading. Again, somebody's brought to a hospital on a self-report of drug consumption. It would be puzzling if there was no evidence as to what the hospital did with that self-report. Certainly, I suggest that the admission of that report in its state was proper. To the extent that perhaps it shouldn't have come in that state, this evidence would have been before the jury in one form or another, so there's certainly no substantial likelihood of a miscarriage of justice. Your Honors, with respect to the cross-examination of the girlfriend, again, the fact that she was in custody was certainly before the jury. She could have been asked about that. It's unclear how her statements to a non-testifying psychologist who found the defendant criminally responsible could have possibly been introduced.
Found the defendant or found her criminally responsible?
Found the defendant criminally responsible.
I'm sorry, remind me again, the interview of her related to the defendant's criminal responsibility?
Yes.
Okay, did the expert testify at trial?
No.
I did, okay. that's
The
where I got
expert
lost.
found the defendant criminally responsible. He did not testify at trial. The girlfriend's statements, if at least in my reading of it, were not actually inconsistent. It was clear that she was speaking to the defendant on the telephone, believed the expert had the recorded calls themselves and perhaps additional ones, that she was relating what the defendant told to her. She wasn't claiming to have personal knowledge of what had happened on an evening when she was somewhere else in custody. Certainly, I suggest there's no problem with the impeachment or non-impeachment of her on that issue. And, Your Honors, as to the other issue, I suggest the OUI instruction the judge gave was entirely proper. Counsel was advised to steer clear of the legal limit for driving, elicited the information anyway. Certainly the jurors, it was appropriate to inform them this was not a driving case and that the .08 was not relevant to the issues that this jury had to consider. Your Honors, if there are no further questions, I would rest on my brief and ask this court to affirm the conviction for the murder of Catherine Mankello, suggest that any reduction in the verdict or anything other than an affirmance of the first-degree conviction would be inappropriate, and request that you affirm the conviction.
Thank you, counsel.
Thank you, Your Honors.